Clashes outside of the U.S. Supreme Court Wednesday between pro-life and pro-abortion protesters. This while inside the courthouse, justices heard oral arguments in the latest major abortion case. The case pits the state of Idaho against the federal government, centering around Idaho's Defense of Life Act. The law protects the lives of women and the unborn, only allowing abortion if the life of the mother is in danger. The Biden administration is suing Idaho, saying that the state law conflicts with a federal law known as the Emergency Medical Treatment and Active Labor Act, or EMTALA. It states that emergency rooms are required to provide care for pregnant women and their unborn children. In 2022, the Biden administration released new guidance on EMTALA, which required doctors to provide an abortion when necessary to preserve the, quote, health of a woman. The Biden administration argues that Idaho's law prevents ER doctors from offering an abortion if a woman needs one in a medical emergency. Some medical professionals claim that they are confused by the Idaho law. But Ingrid Scott, a pro-life OBGYN doctor, has practiced under EMTALA and says it has never been confusing.
Every single state that has pro-life protections allows that intervention. Abortions in this situation are rarely needed. As an obstetrician practicing for over 30 years, I have not needed to perform an abortion to save a mother's life.
The Idaho Attorney General contends the state law does not conflict with EMTALA, but the Justice Department argues that the state law is too narrow and forces doctors to delay care.
Today, doctors in Idaho and the women in Idaho are in an impossible position. If a woman comes to an emergency room facing a grave threat to her health, but she isn't yet facing death, doctors either have to delay treatment and allow her condition to materially deteriorate, or they're airlifting her out of the state so she can get the emergency care that she needs.
Doesn't matter whether it happens tomorrow or next week or a month from now.
There is no imminency requirement. This whole notion of delayed care is just not consistent with the Idaho Supreme Court's reading of the statute and what the statute says.
To further explain this case and its potential implication, let's bring in John Bursch, Senior Counsel and Vice President of Appellate Advocacy at Alliance Defending Freedom. Idaho's law bans abortion unless it's deemed medically necessary to save a mother's life. That said, John, how does this law put women's lives at risk or potentially delay care, as some say, if at all?
That's really ridiculous. People are making up all kinds of hypotheticals that don't involve real medical cases to try to scare the justices into giving them a political result that they want instead of a legal result. The Idaho Supreme Court made clear that when a doctor is judging whether an abortion is necessary to save a woman's life, that it doesn't have to be medical certainty, but simply in the doctor's best judgment. And it says it doesn't have to be an imminent risk to her life, but one that is likely to occur. And so there's plenty of flexibility in those joints for the doctors to make sure that women are getting all the protective care that they need, and at the same time giving the maximum protection to the unborn child. And after all, that's what the federal law was specifically designed to do as well, to protect the mom, but also to protect the baby. After all, there are two patients here. And one of the crazy things about what the Biden administration is saying, this EMTALA law was passed in the 1980s, signed into law by President Reagan after being endorsed by majorities in both parties in Congress, and to somehow now claim that 38 years after the fact, it's an abortion mandate. I mean, that's something only a fiction writer could come up with, and yet they did after the Dobbs decision because the administration hated the result so much that they needed to find other federal ways to require abortion.
Yeah, I'm curious about this. What are your thoughts, on the oral arguments that were made on Wednesday at the Supreme Court, and what were your big takeaways?
Well, the big takeaway for me was an exchange between the administration's lawyer and Justice Alito. And he pointed to that language in the statute about the importance of protecting the unborn child in the emergency room and asked her how she could reconcile that with an abortion mandate. And it really tied her up in knots. She didn't have a clean answer for that and just said, well, the mother's interests always prevail. Well, that's not what the statute says at all. If we're going to enforce the law, we need to enforce all of it. And in many instances where there are emergencies, it's entirely possible and preferable to treat both patients, mom and baby, and to save them both. And there are plenty of examples of that happening in real life.
John, I know we won't know anything until June, but if this were to be overturned, this Idaho law, if it were to be overturned, what would that do to ER doctors and also conscious rights?
Well, that's an interesting question because up until Just last month, during the FDA abortion pill case, another Alliance Defending Freedom pro-life case at the Supreme Court, the federal government had taken the strict position that doctors and hospitals have no conscience rights when it comes to emergency rooms. Now, in the FDA case, the same government lawyer admitted that doctors have conscience rights, but she didn't say that hospitals did. And today, she started to concede that hospitals do too. So they're kind of spinning around in circles as they're trying to decide what position they need to take in order to get a win in this case, which is kind of ridiculous. But the reality is that a legal conscience protection doesn't mean very much in the abortion context, because a doctor, let's say they're an OB/GYN, they're usually on an upper floor of a hospital delivering babies, but they're also a hospitalist. And so they help women who are having pregnancy complications in the ER. And when a woman comes in and they go down, they may have a religious conscience objection on file with the general counsel's office. But as they go into the emergency room and they're scrubbing up, they don't know whether they're confronting a miscarriage or if they're confronting an ectopic pregnancy, or if they're participating in a possible completion of an abortion based on someone taking an abortion pill like mifepristone. And so we really need clear, broad protections, not the kind of statements at oral argument that the government was getting here. And we're going to do everything in our power to make sure that pro-life doctors will never have to participate in abortions in the emergency room or anywhere else.
Yeah, in this case, out of Idaho. But what impact could it have nationwide?
Well, Idaho is one of 22 states that have pro-life laws. Some, like Idaho's, begin at conception. Others are fetal heartbeat laws. Others have other lines. But every single one of those could be overturned by the doctor's subjective judgment about what care he or she thinks is necessary. So instead of state law regulating the practice of medicine and protecting human life, federal government would defer to the doctors in almost every case. And that's not what EMTALA was ever intended to be. EMTALA was an amendment to the Medicare Act. And the very first provision of the Medicare Act says the federal government is not supposed to direct or control state law medical practice or any particular treatments. And so really what the Biden administration is doing is standing the entire statutory scheme on its head in its zeal to find some federal right to abortion.
And John, how would this impact Catholic hospitals, if at all?
Well, that's a great question, because previously the Biden administration had said hospitals don't have religious conscience rights. In fact, they until very recently said that doctors don't even have religious conscience rights when it comes to the emergency rooms. But at the argument today, some of the justices specifically raised the issue of Catholic hospitals that take Medicare dollars and yet have to follow the USCCB's ethical and religious directives, which prohibit abortions except to save the mother's life. And the administration's attorney kind of hemmed and hawed a little bit and seemed to acknowledge that those Catholic hospitals and their doctors would be protected, but that's not written into any federal regulation or any interpretive order. And so that's cold comfort to pro-life doctors who want to make sure they don't have to participate in abortions in the emergency room. So we're hopeful that the court will not only recognize those conscience rights, but will just say that this law, that federal law, which protects life, does not override Idaho's law, which ensures the protection of unborn life.
John, before I let you go, final thoughts on this.
Well, we were really happy with how things went today. We think the justices' questions really exposed the inconsistencies in the administration's positions. We're hopeful that the justices will uphold Idaho's life and uphold the right of all Americans in their states to be able to protect innocent unborn life, and that the federal government can't cram abortion mandates on them, particularly using laws that themselves are supposed to protect life.
All right, we're going to leave it right there. John, thank you so much for your time today and for your insights. We really appreciate it. God bless you.
Thank you very much, Tracy. God bless you and EWTN.